Good morning, everyone, and welcome to this Brodie's webinar on mergers and consolidation in the social housing sector, the regulatory challenges. My name is Jackie McGuire. I'm a partner in Brodie's Government Regulation and Competition team and deal with a lot of housing regulation. I'm joined this morning by a financial expert in the social housing sector, my colleague Chris Dunn. In this webinar, we're going to be looking at the sorts of regulatory issues that might crop up in relation to mergers and acquisitions in the social housing sector. And when we're talking about regulation, we're giving that a fairly broad interpretation. In this webinar, as I said, we're going to look at the regulatory challenges that might arise in relation to mergers and acquisitions. In the second part of the webinar, Chris will be considering different approaches to mergers and acquisitions, how they're carried out in practice, and we'll look at the options through the lens that might be applied by lenders. In this part of the webinar, I'm going to look at the sort of regulatory issues that crop up broadly in the social housing sector, with the focus being on the role of the SHR, taking account of its statutory objective and statutory functions. It is likely, however, that for a number of proposed mergers and acquisitions that involve RSLs, there's likely to be engagement with other regulators, including OSCR, where we're dealing with RSLs that are charities, and the Financial Conduct Authority, where we're dealing with RSLs that are cooperative and community benefit societies. We don't intend to look at those particular aspects of regulation this morning. In all cases, however, the SHR will retain an oversight of what is being proposed and will, in effect, have a role in approving what is being proposed. So the starting point for this part of the presentation is to take a look at the role of the SHR as defined by statute and how that is contextualised in the regulatory framework for the social housing sector. The SHR's role in relation to proposed mergers and acquisitions within the social housing sector is concerned with proposals that involve mergers of or the acquisition of businesses of social landlords that are registered under the register maintained by the SHR under Section 20 of the Housing Scotland Act 2010. And the SHR itself was established by the 2010 Act. The statutory objective of the SHR is set out in Section 2 of the 2010 Act as being to safeguard and promote the interests of persons who are or who may become homeless, tenants of social landlords, or recipients of housing services provided by social landlords. So the SHR has a fairly wide body of interest to look after. The 2010 Act goes on to provide that the regulator must, so far as reasonably practicable, perform its functions in a way which is compatible with that objective and which it considers most appropriate for the purpose of meeting that objective. So a fairly wide level of discretion as to how it carries out its objective or meets its objective. The 2010 Act in Section 3 defines the functions of the SHR as including monitoring, assessing and reporting on, and where appropriate, making regulatory interventions in relation to social landlords' performance of housing activities, and RSLs, financial wellbeing and standards of governance. So maybe just at this point to flag up that social landlords include all social landlords, including local authorities and RSLs, but RSLs are those who are registered on the register maintained by the SHR, and that doesn't include local authorities. Housing activities are defined in the 2010 Act as being any activities undertaken by a social landlord in relation to housing services, which are or may be provided by it, so at the moment and also looking forward. And that can include the provision of accommodation and the provision of other services, including factoring services, so the SHR has quite a broad remit. The Act provides the SHR must perform its functions in a way which is proportionate, accountable and transparent. It's targeted at where action is needed, that encourages equal opportunities, and is consistent with the best principles of regulatory practice. So there's a statutory framework for how the SHR goes about its business. The Act also requires the SHR to publish a statement on the performance of its functions, and that sets out how it regulates both RSLs and the housing and homelessness services provided by local authorities. And that document is commonly referred to as the regulatory framework, and you can find that very easily on the SHR's website. So that framework sets out how the SHR will monitor, assess, report and intervene as appropriate on the governance and well-being of RSLs. And it does that with reference to a number of regulatory standards. And I'm going to talk about a couple of those in a moment. So you can see that the provisions of the 2010 Act provide the SHR with a legitimate interest in the business activities of RSLs, including how they operate within group structures and or when they're considering other changes as to how they operate, including where mergers or acquisitions are anticipated. And in relation to those kind of proposals, the primary interest of the SHR will be how they affect persons who are of interest to them. And their main focus, although it's not limited to tenants, will be tenants. So main interest, focus for the SHR is the impact of the changes on tenants. Now, in its framework, the SHR mentions that it engages with public funders and lenders to landlords. And one of the ways that it achieves this objective is by helping maintain their confidence in social housing. And the SHR considers that maintaining that confidence is really important if landlords are to continue to have access to funds, affordable costs, to provide new housing and support their businesses. And from our own work with lenders, we do know that the regulation of the RSL sector is important to them, and that the SHR's involvement in proposals in relation to mergers and acquisitions is therefore likely to be of significant interest to lenders and funders. At this point, I just wanted to mention that in the regulatory framework, the SHR underlines that it promotes strong tenant voice. It states that it's important that landlords involve tenants and service users in the scrutiny of their performance and in discussions about affordability and what they get for their rent. The 2010 Act provides for a number of duties on RSLs in relation to tenant consultation that are of relevance to mergers and acquisitions, and I'll discuss a few of those in a moment. However, I would just flag up at this juncture that given the SHR's commitment to promoting a strong tenant voice, it does take a keen interest in how, and not just if, tenants have been consulted on matters of significance. And this will include where they are consulted in relation to any constitutional or structural change. So moving on to the next slide. As I've mentioned, the SHR has published its regulatory framework. In addition to setting out how the SHR regulates, the regulatory framework sets out standards of governance and financial management that are expected of RSLs. Now, these standards have statutory status because they're published by the SHR under Section 36 of the 2010 Act, which requires that the SHR publishes a code of conduct that sets out such standards for social landlords. So they have statutory status. There are 7 of these standards in total, and it's fair to say that when RSLs are engaged in business activities, such as mergers and acquisitions, most, if not all, of those standards will be engaged. So I'm going to talk about a couple of those on this slide. First bullet point I have here, leadership and business planning. Standard 1 requires that the governing body or the board leads and directs the RSL to achieve good outcomes for its tenants and other service users. Consequently, the SHR will want to know that the governing body or board has ownership of any proposed merger or acquisition process, and that it is satisfied that the proposal accords with the RSL strategic direction. So major changes like acquisitions, consolidations are not just matters for senior officers within an RSL. The board must lead in relation to such proposals, and its leadership must be reflected in its minutes. That's the kind of thing that the SHR will be looking for. Standard 2 of the framework is concerned with openness and accountability. In other words, the RSLs provide tenants and service users with information that meets their needs. And the SHR will be concerned about the accessibility of such information, as well as the detail of the information. And it will also want to know that landlords are open to answering questions and agreeing to requests for information about their work and their plans. And Standard 3 requires that RSLs manage their resources to ensure their financial well-being while maintaining rents at a level that tenants can afford to pay. So when it's considering any proposed merger or acquisition, the SHR will want to be provided with information about and be assured that the proposal is Standard 3 compliant. it will have a keen interest in what the proposal means for tenants. Now, that doesn't mean necessarily that the SHR will expect that the proposal doesn't result in rent increases. It will, however, want to be assured that where rent increases are likely, there are commensurate benefits and that overall rents remain affordable. And commensurate benefits might include increased security and financial stability and are not necessarily limited to improved levels of service delivery. So standard 4 requires that governing bodies base their decisions on good quality information and advice and that they identify and mitigate risk. So when it's engaging with RSLs that are proposing structural change, the SHR will be interested in first the quality of the advice that's been provided to the RSL, and secondly, that where expert advice is required, it is being obtained and is being taken into account. And the SHR will on occasion decide to test the robustness of that advice, including through the employment of its own expert advisors. So a wee bit there on the standards. So moving on to the next slide, I wanted to look at standard 7 in particular. So what's on this slide is what the heading in standard 7 says. And standard 7 will be complied with where the RSL ensures that any organisational changes or disposals it makes safeguard the interests of and benefit current and future tenants. So looking at how they safeguard interests now and how they will safeguard those interests going forward. And some of the key bullet points that you find below that heading include that where an RSL is considering organisational or constitutional change or disposals of land or assets, the governing body will discuss any proposal for organisational change and ensure that the proposal will benefit current and future tenants. And the SHR will be looking for evidence that those processes have been followed. So coming back to that point about minuting decisions, so there's a clear record that the governing body has control and ownership of the process. The SHR will also want to ensure that the RSL has ensured adequate consultation with and support from key stakeholders, including tenant members, funders, some of whom may need to give specific approval, and local authorities and other regulators, including, for example, OSCR. So the interface around local authorities might include, for example, does the proposal have any implications for the local authority in relation to things like standard Section 5 referrals? And does it have any implications in relation to, for example, the Common Housing Register? The SHR will also want to know that the governing body is satisfied that any new or any changed organisations, so a brand new RSL or any assumed RSL, will be financially viable and efficient and will provide good outcomes for tenants. So again, it's that looking at the standards at the moment and looking at the standards going forward. What's also of keen interest to the SHR under Standard 7 is that the RSL establishes robust monitoring systems to ensure that delivery of the objective of the change, so you've set out to do something, are you achieving it? And also of the commitments made to tenants. So it wants to know that those are going to be achieved. And types of commitments you might see in relation to structural change might include commitments relating to service standards, operating costs and investment levels. So if an RSL is making commitments to its tenants as part of the case for organisational change, the SHR will want to know how those commitments will be monitored and delivered. It will want to see your delivery plan. And Standard 7 also requires that the RSL complies with regulatory guidance on tenant consultation, ballots and authorisation. So statutory compliance will not be sufficient. That's the minimum hurdle that has to be cleared. And I'm going to talk about those differences in a moment. And finally, Standard 7 requires that the RSL notifies the regulator of disposals, structural change, in accordance with regulatory guidance. And in a moment, I'm going to talk a wee bit about the difference between what the 2010 Act requires in relation to notifications and what the regulatory framework requires in relation to notifications. The two things are not the same, but both must be complied with. And that's because, as I've said, the standards that I've been talking about here have a statutory basis, which means that compliance with those standards is mandatory. So next slide, please. As I've said, all RSLs are required to comply with the standards of governance and financial management issued by the SHR and all associated statutory guidance issued by the SHR. And that includes guidance issued in relation to constitutional partnerships and group structures that may be of relevance where, say, an RSL is being assumed as a subsidiary within a group structure. And regulatory requirements require RSLs to submit information to the SHR in relation to, among other things, group structures, tenant consultation where it's required, and financial viability. And those requirements include a duty to report to and to provide the regulator with information where structural or organisational changes will have or are likely to have an impact in any of those things. So we're talking about forward notification here, notification in advance, not notification at the point of implementation. RSLs must adhere to statutory guidance, and the SHR does make that quite clear in the regulatory framework. It does, however, recognise that in exceptional cases, a departure may be appropriate. However, the SHR has made it very clear in the regulatory framework that where an RSL is proposing a departure, it should discuss why this is considered necessary before acting on it. And an example of the statutory guidance that's been issued by the SHR is the guidance that's issued on tenant consultation and approval, which explains what RSLs need to do if they propose to sell or transfer tenants' homes, restructure or take other decisions that could significantly affect tenants. It covers situations in which RSLs are required to consult with and seek the approval of affected tenants for what it proposes to do, including tenant consultation and approval under sections 115 and 115A of the 2010 Act. And those apply in circumstances where landlord proposals involve the disposal of property that will result in a change of social landlord. So very pertinent to acquisitions, consolidations and mergers. The stated expectation of the SHR is that RSLs should adopt in full requirements that are set out in that guidance, and that's actually the legal position. If there's statutory guidance, you should be complying with it. As I've mentioned, the SHR does provide that if there's exceptional circumstances, you may want to discuss with it why you want to depart from the guidance. If you're going to do that, what the SHR says is come along with your explanation. So tell us why you think a departure is appropriate. And going back to the point I've made earlier, the expectation is that this discussion, these reasons will be put before the SHR before you act on the departure. Where the SHR has published regulatory guidance which is non-statutory, it doesn't require advanced consultation where a departure is being considered. So you get more flexibility where guidance is non-statutory. Nonetheless, it might be advisable to talk to the SHR about a departure that's proposed in relation to non-statutory guidance. That's because the SHR may well want to know why you're departing from non-statutory guidance, because the SHR will not unreasonably be of the view that its published non-statutory guidance will reflect best practice. And if you're not adopting what it considers to be best practice, you ought to have an explanation for that. If an RSL is proposing to dispose of tenanted houses, it must notify the SHR. The notifiable events guidance issued by the SHR also advises that RSLs must notify the SHR of major change or restructuring within the current RSL or group structure. And it's useful to look at the notifiable guidance for a bit of, well, guidance really, because it doesn't just say what you have to notify about, it also provides some advice on how the SHR ought to be notified. So what you need to be telling the SHR about your proposals. Okay, moving on to the next slide. I'm going to talk a wee bit about tenant consultation and approval in relation to structural change. The 2010 Act provides that where an RSL is proposing to make a disposal of tenanted properties, it has to serve notice and tenants of each of the houses included within the disposal, and the notice must tell tenants, well, who you're going to dispose of the house to, It must explain the consequences of the disposal for the tenants. You need to let them know they are entitled to make representations and they've got a time limit for doing that. And landlords should include such other information as they consider appropriate. Now, once you've done that, the RSL should take account of any representations made, and it's then required to serve a further notice on the tenants, informing them if they are proposing any significant changes to the proposal, and also explaining that the disposal requires the approval of the tenants, and that might be achieved by way of ballot or written agreement. And most commonly, it's done by way of ballot. These are the basic requirements of the tenant consultation process. That's a pre-requirement of the tenant ballot that's provided for in section 115A of the 2010 Act. So the disposal process, getting approval for it, is a two-stage process. Once the consultation has been concluded, and if the proposal is to proceed, you'll move on to the ballot or getting written agreement of the tenants for the proposal. And section 115A of the Act provides that you have to conduct a ballot of tenanted houses if the proposal is to proceed. You have to, if you can't do that, or if you think it's more appropriate, so for smaller RSLs, it might be more straightforward, simply to get the written agreement of tenants of houses, including it in the proposal. It also says that you must, as soon as reasonably practicable, after the ballot is completed or the period for given written agreement has expired, and before making the disposal, notify the regulator of the results of the approvals exercise. Now, that's what the Act says, but it's quite clear from what I've said earlier that notifying the RSL, notifying the SHR of the outcome of a ballot or obtaining written agreement on a proposed disposal, it is coming far too late in the process to be compliant with the regulatory guidance. Since the 2010 Act was amended in 2018, it's no longer a statutory requirement for an RSL to obtain the approval of the SHR to the disposal. But as I've said, the proposed disposal will be a notifiable event. And in addition, as I've said, you'll have to have regard to the statutory guidance issued by the SHR in relation to such disposals, which clarifies that the SHR must be notified at an early stage in the RSL's deliberations. So it's clearly very evident that the SHR must be advised of proposed disposals well in advance of the commencement of the statutory processes that are provided for in the 2010 Act. And in addition to ensuring that RSLs are meeting the minimum requirements that are set out in the 2010 Act, the SHR is very keen to ensure that the RSL is open and accountable about what it proposes, and that the consultation and notification exercise complies with the principles of proper consultation, including that tenants are provided with sufficient information that meets their needs. And that's all in line with the expectation that the SHR has of RSLs under Section 2 of the regulatory framework, which I mentioned earlier. As I've mentioned also, the SHR has issued guidance on tenant consultation and approval, and that guidance must be followed. And if you're going to depart from that guidance, you'll need to explain that in advance to the SHR, and you'll need to explain why any departure doesn't prejudice your tenants. The guidance really does beef up the basic requirements that are set out in the 2010 Act. It sets out, for example, that where the disposal is to another RSL, the notice should include as a minimum information for tenants on the implications of their tenancy and all the rights and responsibilities contained in that tenancy, and details of the proposed membership and governance arrangements that will come into place once the structural change has been implemented, and details of any investment or service consequences, including the scope and timing of those consequences. And before I move on to the next slide, I just wanted to mention a particular requirement of the guidance, which is the provision of independent support for tenants, which is not something that's included with the 2010 Act, but which is something that's inescapable because of the statutory status of the guidance. The SHR is of, I think, the not unreasonable view that the implications for tenants where tenanted homes are being sold or transferred can be significant, and the detail and rationale for proposals can be very technical. And it's important, therefore, that tenants are able to understand the implications of the proposal and that they can obtain advice from an independent source. And for that reason, the SHR advises that RSLs should make arrangements for the provision of free and independent advice to tenants of each house included in the disposal, and that tenants should be able to access this resource from the outset of the consultation. So going back to the point I made about early engagement with the SHR, it will want to know early doors up front before you embark in the consultation that it's going to be compliant with the guidance. So you have to engage them early doors. So moving on to the final slide, this part of the webinar. Some top tips for engagement with the regulator. 1, engage early. Why? Firstly, because I think I've made it quite clear you have to. It's a regulatory requirement that you notify at an early stage. But secondly, and of equal importance, because it's helpful. The regulator won't provide an RSL with legal advice, but it can provide support and guidance. It can also identify any obvious gaps or concerns before an RSL embarks on a formal consultation process. So areas in which an RSL may find support and guidance to be of assistance might include how to structure the consultation or notification process such as it meets the SHR's expectations, including independent support for tenants, for example, through TPAS or in that process. It will also help raise any other red flag issues. So for example, if one RSL was proposing to transfer to another RSL that wasn't complying with the regulatory framework, that would beg a number of questions that would need to be answered before the SHR be satisfied that the transfer was a good idea. Early engagement will smooth the process and avoid unwelcome surprises. So it's a good thing. It will help you get to the situation where the regulator will look favourably upon your proposal before you've done anything that commits you to taking the proposal forward. The SHR will also be looking for a strategic options appraisal. None of that's in the Act, but it's something the SHR will be looking for. And we know that from the work that we have done with the SHR. So where an RSL is proposing a merger or acquisition or to join a group structure, it will expect that the RSL in question will have prepared a comprehensive and robust strategic options appraisal that considers its objectives and the means by which they might be met, including a consideration of available options, so not just one option, but what other options might be available by which you might meet that objective, and that will look at the pros and cons associated with each of those options. And the appraisal, and this is quite important, should consider the capacity of the RSL to deliver its preferred option. You know, it will call into question your proposal if you don't have the capacity in-house to actually deliver on it. Now, preparing a comprehensive strategic options appraisal will take time and may involve expenditure. But our understanding is that a robust options appraisal is key to smoothing the regulatory path to progress. Engagement with other regulators will also be of interest to the SHR. The SHR has a specific role to play in relation to the regulation of the housing sector, and while it won't seek to engage in activities that are the preserve of other regulators, such as OSCR, it will want to know that where engagement with other regulators is necessary, such as I've said, engagement with OSCR, that engagement is taking place. So if you need to be talking to OSCR about the transfer of chargeable assets, let SHR know that OSCR has been consulted and let it know whether or not approval of OSCR will be forthcoming. And post-transfer merger or delivery, they want a tidy outcome. The SHR wants a tidy outcome. When a proposal is put forward on the basis that it will deliver benefits for tenants, the SHR will want to know that the RSL will monitor delivery of those benefits. And the SHR will also monitor and track delivery of those benefits through its engagement plan with the receiving or merged entity. So you don't get away with just making the promises, you have to deliver on them. And where a merger or transfer has been undertaken, the SHR will also want to know that there are plans to complete any outstanding legal requirements, for example, notifying Companies House or the Financial Conduct Authority that a company or a registered society has been wound up and that arrangements are in place for lodging any final accounts, you know, that sort of technical stuff. It will also want to know when an application will be received in relation to the removal of any transferring RSL from the Register of Social Landlords, and it may request some information in support of that application. So that brings me on to Chris's part of the webinar. We're taking account of things I've just said. He's going to be looking at mergers and consolidations, options, and I think you're going to be applying a wee bit of the lens of a lender here, Chris.
Yes, thank you very much, Jackie, and good morning, everybody. I'm going to just look at some of the options for how mergers and consolidation transactions are structured. It's really just building on my own experience as to how I've seen these sorts of transactions dealt with over the years. But as a precursor to that, I would say that before we consider options for how to structure a merger or consolidation between two social housing providers, we really need to step back and take time to consider why the parties are considering such a transaction and what their objectives are. We also need to be conscious, particularly when we're advising, that the objectives of the two parties, they may differ. One party may be entering into the transaction for one set of reasons and the other for another set of reasons. And frankly, the greater the difference between the parties, the more likely that such a transaction will fail in my experience. So common reasons for considering a merger would include that one party, and it's generally the smaller of the two, is under financial pressure, and it's leading it to seek a larger, more financially secure partner. Another common issue are regulatory concerns, particularly from a corporate governance perspective, affecting generally the smaller of the two parties. A further reason might be that the two associations might recognise that they'll benefit financially from cost savings from being a larger combined entity. Over the years, another theme has been the retirement of a long-serving chief executive. That tends sometimes to be a trigger point for parties to consider their futures and whether they should remain independent or would benefit from merging with another entity. I think it's fair to say also for some smaller associations, there's nowadays a struggle to fill board positions. And also to comply with what is an increasingly complex regulatory and financial framework under which they need to operate. So there's all those sorts of issues facing housing associations or RSLs, and the critical issue is whether the parties think there would be a good cultural fit and whether they wish to plunge into full-scale merger or whether they prefer some sort of interim bedding in arrangement before they get to the position of a full merger. So if we consider it, I mean, in practice, I think there's four principal options. But these all can vary, and there can be sort of permutations round about them. But the four principal options, as I would see it, are: first, a structural alliance; secondly, an asset acquisition; thirdly, a corporate acquisition; and fourthly, a transfer of engagement. And each of those has its own pros and cons. So if we consider them each briefly, if we look at a structural alliance, by that, I mean an arrangement that creates a close working relationship between two or more associations, but with those associations remaining constitutionally separate. So when we encounter this, there's normally a formal agreement which would set out how the parties are going to work together, how they'll share skills and services, and generally support one another. Normally, there's also a shared board that would be put together with members jointly appointed to operate within a framework of reference. So that's all really designed so that the association can then tap into the expertise of each other at board level. So in terms of the pros for that sort of arrangement, identify potential for cost savings. Joint employment of staff might create efficiencies. There may be minimal impact on the loan covenants, staff pensions, etc. It should be relatively straightforward to achieve, depending on the nature and the full extent of the relationship. It can be used as a stepping stone to a full merger if the parties don't want to go down that full route at the offset. And classically, it's easier to dismantle than a full merger. You're going down a full merger, it's more difficult to take it all apart. If you go down this, some sort of strategic alliance arrangement, it's much easier to take that apart if the parties decide that's for the best. Against this, and in some ways, this depends how this has been sold to key stakeholders. It perhaps shows a lack of commitment. It necessitates retention of separate boards, which can be an issue. It may not adequately address regulatory concerns, and it perhaps lacks clarity when it's been sold to tenants and other stakeholders to exactly what parties are doing. But that's, I suppose, the most unobtrusive arrangement. The next one would be an asset acquisition. So here you just have an arrangement under which one association enters into a contract to buy specific assets from another association, perhaps housing or other assets. So in principle, that's straightforward. But in practice, if you're dealing with the transfer the whole or substantially the whole of the assets of one association to another, it's likely to be much more complex, and you're potentially going to face numerous consent issues required for a business to transfer from one party to another. You also have to address how you're going to transfer liabilities. That as a matter of law, it requires an innovation. So you're probably going to need lots of involvement from third parties to transfer over those liabilities. So therefore, I would suggest that unless a transfer engagement is not going to be feasible for technical reasons, an asset acquisition in practice is likely not to be a viable approach. So in terms of if I identified a pro to that approach, it might be a preferred solution if less than the whole of the assets and liabilities of one association are to be acquired by another. Or if it was a very small association, just owning a handful of properties, it might just be a good arrangement to transfer those properties. On the cons, it's likely to be a cumbersome process, and consequently, it's going to be costly. You're still going to need ballot approval if housing subject to tenancies are to be transferred, and you're also going to have to address what you do with residual assets and liabilities if you just transfer part of the assets of one association to another. So overall, probably not that viable as a solution. Third option is a corporate acquisition. So that's where one association acquires another association, creating a group structure, and the second association becomes a de facto subsidiary of the first. So in practice, that's achieved by the second association, target association, adopting new rules or constituted documents to which a golden membership interest is created in favour of the first association. Parties then commonly enter into what's called an independence agreement to regulate the arrangements that will apply between them, and we often see that as a structure preferred where you've got an existing group structure. In terms of pros to that, it can have a lesser impact on loan covenants and potentially things like pension liabilities. That might benefit in terms of cost of the transaction. It's also useful structure where the parties want to retain, at least initially, their individual identities post the merger transaction, and it can help to keep the activities of the merging party or one of them ring-fenced from the other. So that could be useful, particularly in the bedding in period. And lastly, I would just highlight that it's a structure that would be simpler to split if the parties decided at some point to go their own ways again. Whether that could be seen as a pro, maybe it's also a con as well. So on cons, you could say that the two associations remain separate entities. So there's no true merger, so maybe a difficult sale to sell that in some ways. There's a continuing need for separate boards, which is not great, particularly if you've got a large group structure and you end up with lots and lots of separate boards. If there's to be any restructure of staff and assets, that might have to be delivered manually, given there's going to be no automatic vesting. That would be on the transfer engagements. So the fourth option, and the one we obviously see a lot of, is a transfer engagements. That's a statutory procedure under the Cooperative and Community Benefits Societies Act, and it's under which the whole of the assets of one association can be transferred to another. I won't today go through all the loops you need to comply with under the 2014 Act, but you do have to follow them strictly. And we have seen situations where there's been a question mark over whether they have been followed. That sort of creates all sorts of risk issues in terms of potential for judicial reviews by aggrieved parties if the terms of the Act have not been strictly complied with. My strong recommendation would always be to take advice in terms of implementing such a transaction to ensure that the requirements of the Act are followed as required. So the pros on that are it's got the huge benefit that it just transfers everything, assets and liabilities, from one party to another, just creates a new single unified entity. There's no requirement for separate assignations or assignments, novations of assets and liabilities, and there'll be one continuing board governing the combined entity. On cons, I would emphasize again the statutory rules need to be followed, otherwise it might all be subject to potential challenge. Need a ballot again. It doesn't abrogate need for due diligence in the target association, or and I think sometimes forgotten, the acquiring association as well. I think that's all probably that I would like to cover today. I think everybody's probably listened for a long time now. So I'm just going to hand back to Jackie just to wrap up for us.
Thanks, Chris. I would just at this stage say I don't think we have any questions at the moment. I wanted to flag up, however, that we do have in our current social housing series still to come a webinar on social housing, mould and damp considerations for landlords, and that will take place on the 13th of June at 2 o'clock. It's obviously a very hot topic at the moment and of considerable interest to the Scottish Parliament. But beyond that, thank you all for joining us this morning. Have a nice day, a nice afternoon.